Welcome, welcome. At this time, we will call to order. Call to order for our July regular Board of Adjustment meeting for Buncombe County. Excited to have you all. We'll start with a welcome and announcements. Any announcements from staff today?
I won't spend a lot of time talking about this because I know you all have a lot to get to today, but my intention is later this week, I'm going to be sending out an email with information about a new system for confirming member attendance at meetings that will hopefully resolve some of the issues that have been raised in recent months. So I won't go into detail now, but I just want you all to be on the lookout for that. Thank you.
Thank you all for working on that. We appreciate it. And we'll encourage board members, staff, and the public at this time to silence your devices. Put it on silent or low volume so we're not disturbed during the meeting. And also that if you have to take conversations outside, we'd appreciate that. If you have a prolonged conversation with a neighbor, please step outside for that. We'll start with a roll call of board members and then staff.
Joe Mazzellis.
Paul Wilazinski.
Craig Allen.
Andy Ball.
Catherine Morsani.
Greg Phillips.
Gabe Quisenberry.
Jason Payne.
Savannah Glantz.
Kurt Euler.
Griffin Kearns.
Thank you. Item D, election of chair and vice chair. It's the July regular meeting, and our rules call for election of chair and vice chair once every year, and this is that time. So we'll open up the floor for any, and we'll ask for staff's input first. Anything?
I'm sorry. I would just open it up for nominations for chair, and then we'll, depending on that, then we would vote on the chair, and then we would open up nominations for vice chair, and then elect the vice chair.
I nominate Andy Ball.
I'll second that.
Wonderful. There's a nomination.
Are there any other nominations for chair? Then I would suggest closing the nominations and then holding a vote.
I make a motion to vote Andy Ball as chair.
I guess all those in favor?
Aye.
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 Any opposed? Congratulations.
Thank you. Thank you.
I guess then for vice chair, you can open nominations?
I'll nominate Catherine Morsani if she's willing to serve.
Second.
Yeah.
Okay, thanks.
Are there any other nominations for vice chair? No? Hearing none, then I would recommend closing the nominations and then vote.
All those in favor?
Aye.
Aye.
Aye. Thank you.
All
Any
right,
opposed?
congratulations.
Passes.
Okay.
Thank you all very much. Look at that. Approval of meeting minutes. We do have meeting minutes to consider from last month, and we do have also a revision that came through maybe last week. Is that right, Griffin?
So the revision was to the minutes from the May meeting, and the revised minutes from the May meeting were approved in June. So
Okay.
what you would be looking at today are the ones that I sent out yesterday, the minutes from June 11th meeting.
And that revision then was from the May minutes. Is that a clerical revision that y'all can make internally, or do we need to do a motion to reconsider and consider?
The board voted at its last meeting to approve those revised minutes.
Got it.
So that
Okay.
was already taken care
We're
of.
set then, okay.
Okay, I make a motion to approve the minutes.
There's a motion and a second. All those in favor, please say aye.
Aye.
Aye. Any opposed? That passes. Thank you so much. Moving to disclosure of ex parte communications and conflicts of interest. That's defined by our statute this way. A member of any board exercising quasi-judicial functions pursuant to North Carolina General Statute shall not participate in or vote on any quasi-judicial matter in a manner that would violate any person's constitutional rights to an impartial decision maker. Impermissible violations of due process include, but are not limited to, a member having a fixed opinion prior to the hearing that is not susceptible to change, an undisclosed ex parte communication, close familial, business relationship, or other associational relationship with an affected person, or a financial interest in the outcome of the matter. So because we're quasi-judicial and that's the setup for our board, we can't have conversations with each other before the hearing or with anybody really outside in the general public. And so unlike commissioners, for instance, or planning board members, et cetera, who can have those conversations, we're restricted in that way. Staff, do you have guidance on this?
Yes, this is actually a new one for us. So it is my understanding that there was a posting on, or maybe multiple postings on an Asheville Reddit page. There's possible Facebook postings about one of the cases. I believe it is the Stern Stormwater variance that has been on, and I think that we are going to treat. It is also my understanding that some of the board members' phone numbers have been published, and you may or may not have gotten calls from citizens regarding this. So I would, for the Stern Stormwater variance, I would first like to know if anybody has had any ex parte communications, and I would include reading the Facebook post or the Reddit post. And I would also, so I think that would be the place that I would like to start regarding
Okay.
the Stern variance.
So if you've been contacted or if you've read something online.
Okay, I was contacted by phone.
We'll do a show of hands first here, if we can, right?
Yeah, how many people have been contacted by a phone call or somebody calling you? Okay, so let the record show Chair Ball, Vice Chair Morisani, and Member Phillips were all contacted. Did you speak to anybody about that or about the case, or somebody just left you a message?
I spoke to them to say I'm not allowed to speak to you and hung up immediately.
Okay, that's a good way of doing that. All right, is there anything about that contact that would somehow interfere with your ability to render a fair and impartial decision on this matter today?
No.
Anybody
All
else
right.
talk to anybody?
A member of the community forwarded a Facebook page to me, and as soon as I realized what it was, I did not read any further.
All right, so let's tackle the Facebook post, all right? So nobody else has received any phone calls from citizens regarding the variance request?
Missed phone call, at least one, maybe two, and then two direct texts.
Okay. Is there anything that regarding that would somehow interfere with your ability to render a fair and impartial decision?
Not at all.
All right, and I would just caution that if you did speak to anybody or they did disclose any information to you, that is not to be considered. Only evidence presented at the hearing can be considered in a quasi-judicial decision. So the second issue is the Facebook post. I guess we would want to know, by a show of hands, how many of you saw the Facebook post or the Reddit post regarding this variance request?
If someone told you about the post, but you didn't see it, is that included in your question?
Why don't we just, that you heard that there was a post? I don't think if you actually read the post, it would count. So if you just heard about it but didn't view it or anything, but you just letting me know that you heard about it. So why don't we just say, if you heard about a Facebook post regarding this, just if you could disclose that.
I heard about it.
All right. And I would ask all the board members the same question. Did anybody actually read the whole Facebook post?
No.
No.
All right. With that said, is there anything about the Facebook post that would somehow interfere with your ability to render a fair and impartial decision?
No.
No.
Okay. I believe that we are okay to move forward on that. I do just want to make a note, since there's a lot of members of the public. This is the Board of Adjustment, and the Board of Adjustment is what's called a quasi-judicial hearing, and that their decisions are based solely on the evidence that is presented at the hearing, based on witnesses and competent and material evidence. So it's different than, let's say, a county commissioner meeting where they're voting on an ordinance, where their decisions don't necessarily, they can be based on really anything. So The difference, though, is that the county commissioners can receive emails, they can, hear evidence outside of the hearing or hear information outside of the hearing. That is not the case with the Board of Adjustment hearings. So I just want everybody to make sure that they understand that distinction. And the reason that we're pulling the board and asking them the questions is that all the parties who are participating in this hearing are entitled to a fair and impartial decision maker making the decision. And if somebody is inappropriately influenced outside of the evidence that's presented at the hearing, that would present a potential due process problem for basically whoever wasn't successful in the hearing. So that is why we were very cautious about that, and that is why that these things are not, for a quasi-judicial hearing, it is not appropriate for the general public to be contacting the Board of Adjustment members outside of the hearing. So I just want to make sure that we're clear on that. Thank you.
And having said that, we're glad you're here today and would like to hear from you during the witness portion of our hearing on each case. If you prefer to have a comment with the board, you can do that informationally at that time. Just to be crystal clear here, anybody else have a conflict on Laurelwood or Asheville River Cabins? No. No?
No.
Okay. Thank you so much. Moving to public hearings. This hearing is a quasi-judicial evidentiary hearing, as we've mentioned. That means it's similar to a court hearing. State and local law set specific procedures and rules concerning how this board must make its decisions. The board's discretion is limited. We must base our decision upon the competent, relevant, and substantial evidence in the record. Our decisions must be constrained by the standards in the zoning ordinance and based upon the facts presented. If you'll be speaking as a witness today, please focus on the facts and standards and not personal preference or opinion. Matters of personal knowledge and specific facts are acceptable. Opinion and speculation regarding traffic, impact on the community, crime, etc., is not. We do value a transparent process and encourage the community to remain engaged and participate. But given this is a hearing on the record, there are certain topics and areas that limit the type of testimony we can receive from members of the public without standing. And at this time, I think we're ready to proceed with our cases, unless staff has anything else. Okay. And we have ZPH 2025-0009, Laurelwood Village Phase 2 Special Use Permit Revision. And we have Jason Payne with staff.
Please raise your right hand and state your name.
Jason Payne?
Do you swear or affirm to tell the truth and nothing but the truth?
Yes.
Thank you.
All right, so I have here that this is a review, and I certify that the public hearing was properly noticed and all applicable parties were notified of the meeting in accordance with general statutes and county code. I ask that all applicant and staff materials be accepted into the record as evidence.
Without objection, so accepted.
All right, this is the review of ZPH 2025-00009, Laurelwood Village Phase 2. The applicant is Tim Fleischauer of Sandhauer Properties LLC, which is the property owner. The project is located on an unaddressed open space parcel off Heartleaf Circle. This is in South Asheville off of Ledbetter. And the total acreage of this open space parcel is just over 4 acres. This is a second phase. The first phase was approved by this board on February 12, 2020. It was a 29-unit townhome-style development there, and they are seeking to add 4 additional units there in the western part of the parcel. It is serviced by public water and sewer. They are requesting, as part of this planned unit development, reduce setbacks to accommodate the shared wall line on these new lots. Minimum lot size reduced to pretty much a postage stamp lot, the minimum of which is 2,250 square feet, and a reduction in building separation reduced from the standard of 20 feet to 17.5 feet. If approved by the board, the staff recommends the following conditions of approval, which I will summarize. A major subdivision plat must be submitted, approved, recorded, and new pins assigned and reflected in the Buncombe County GIS prior to site plan review applications. And the plat must indicate some sort of legal deeded easement connection to the private road of Waitstill Drive on the neighboring pin. And of course, this project must be constructed as depicted in the site plan. And that is all I have. Does anyone have any questions?
Question, Jason. The requested adjustments, how do they compare to any adjustments that were made when the original Phase 1 was approved?
They are consistent with those deviations. It is consistent usually in a townhome development. In standard zone property, since they have a minimum lot size, they would usually need to, well, they would pretty much always need to request for reductions in interior setbacks and lot size, and in building separation usually too, to accommodate that development, really. There is no parking deviation on this one. That is another one that comes up pretty frequently, but the parking is satisfied on this as per the parking standards.
Thank you.
Other questions for staff? Thank you.
All right, thank you.
Before we call the applicant up, we'll ask if there are any members of the public here to assert standing in the case, to be a party to the case. Anybody that notified staff in advance on this? Okay. Any standing applicants in the audience? Going once, going twice. Thank you. And the applicant or the representative, Mr. Goforth?
Yes.
How are you?
Good.
Welcome. We'll swear you in.
Please raise your right hand and state your name.
Michael Goforth?
Do you swear or affirm to tell the truth and nothing but the truth?
Yes.
Thank you.
Good
Welcome.
afternoon. My name is Michael Goforth with High Country Engineering. I'm here with Tim as well, here to represent the developer on this project. I don't have much more to add other than what staff has provided already to the project before we got up here. We are proposing a basic four-home townhome addition to an already approved SUP. The buildings and everything will look very similar to what's already there. So that's the overall goal of the project. They will fit on open space that was previously part of the project, but we've analyzed everything to make sure we're still in large agreement with the original SUP. The projects are accessed by two shared private driveways off of Waitsale Drive, which is also a private driveway. We have permission. We're going to have to work with the HOA there. We have a permission letter from them to state that they agree to allow us to do that access. I'm certainly here to answer any more questions that you may have. I don't have anything else to add at this time.
You bring anybody else to testify today?
No, I did not.
My only question would be about the retaining walls. I see two proposed, one behind, sort of uphill from the last townhome, and then between the two coupled townhomes. I'm on page 4 out of 5 of the C4, rather, on the drawings. The retaining wall profile we see here below the insert, does that describe sort of the dynamics of both of those retaining walls, or are they different in some way?
The one on the, I've got a laptop here in front of me. I'm not sure exactly what you're looking at, but the one on the top side of the project, so I'll say north, I assume we have it rotated north on
Right.
the page. That one is the one that is much larger in scope than the other one. There's another one that's kind of in between the two units there. The one on the rear side up against there's a Duke power line easement back there. That one is about, I think it's around 15 feet tall, somewhere in that range. But that's the intent of that, yes.
And it's not stepped, it's a
It's a
Single
straight
wall.
vertical wall.
okay, 15. And the one in between the units,
It's a lesser height wall. I believe it's around 4 to 6 feet in height on that, Andy.
so the elevation, without counting the layers here on the map and zooming in, what's the difference in height from the floor from each?
So the
double
top of the
unit?
wall, the wall specifically in between the two units, the top of the wall will be even with the upper unit's finished floor elevation, and the bottom wall will be even with the lower unit's finished floor elevation.
Okay. Thank you so much. Board questions, Mr. Goforth? Going twice, going 3 times? Good, look good? Okay. Sounds good. We're all set. You any closing statement or anything?
Nope. Thank you very much.
Sounds good. This time we'll ask if there are members of the public here to speak on this agenda item on Laurelwood. For or against? Going twice, going three times? Thank you, we're all set. This time we'll close the public hearing and open up for board discussion and deliberation and motion.
I think this looks like a good project. They're within all the rules. And I make a motion that we approve it.
Okay,
And I don't have a motion sheet, if anybody has a motion sheet handy.
I'll pass this down here. There.
Yeah, Laurelwood. All right, Mr. Chair, based on the evidence presented to this board, including the following exhibits, the petitioner's application, the submitted development plan, the GIS maps, the staff report testimony presenting, I move that the board adopt the following findings of fact: that the matter was properly advertised, is within this board's jurisdiction, and is ripe for consideration; that this application, together with the conditions proposed by staff and/or this board and agreed to by the applicant, if any, does meet the requirements for granting a special use permit contained in the Buncombe County Code of Ordinances, Section 786213.
There's been a motion on findings of fact. Is there a second?
Second.
Hearing a motion and a second, all those in favor, please say aye.
Aye.
Any opposed, nay? Thank you, that passes. Is there a
Okay.
second motion?
Based on the foregoing findings of fact and for the reasons set forth therein, I move that the requested special use permit be approved and that the order approving the permit be adopted and executed as presented and as modified in this meeting.
There's been a motion for approval. Is there a second to that?
Second.
Hearing a motion and a second, all those in favor, please say aye.
Aye.
Any opposed, nay? Thank you, that passes. Thank you so much. We'll ask our attorney to come present a order on this one.
Trying to see if I can get my screen. There we are. All right. Mr. Chair and the rest of the board members, I would propose the following the following order: that this matter was for a special use permit for the addition of 4 townhome units, level 1 PUD. This is for PIN number 9634-92-0716. This property is owned by Sandower Properties LLC. That this matter was properly advertised and the board has jurisdiction. That the property is zoned in an R1 residential district, that the applicant and other parties withstanding were given an opportunity to participate, and that the board makes the following findings of fact: that this is a plan unit development PUD based on the standards of Buncombe County Zoning Ordinance 78B6, that the land within the PUD will be under single ownership before final approval, that the density is consistent with the intent of the district, which it is located and conforms to the permitted, and that conforms to the permitted in the district which the development is located. The land uses are compatible with and do not violate the zoning district and do not disrupt the character of the community, that the proposed land use meets the minimum requirements in the following manner: that the minimum lot size requirements for interior setbacks do preserve the spirit and intent of the density requirements in the R1 zoning district. The proposed heights set forth in the application do comply with the spirit and intent of the zoning section with respect to the development plan. The board finds that the minimum distance between buildings will ensure adequate air, light, privacy, and space for emergency vehicles, that the development does provide reasonable visual and acoustical privacy for all dwelling units. Fences, barriers, and landscaping will be used for the protection and aesthetic enhancement of the property. That the structures located on the perimeter of the development will be set back from the property lines and rights-of-ways of abutting streets in accordance with the provisions of the zoning ordinance. The board finds that the parking does comply with the spirit and intent of this section. The board finds that the open space recreational areas, if applicable, are compliant, and the board finds that the envelopes, the building envelopes shown on the submitted site plans depict the maximum expanse of the proposed footprint of the structure. That pursuant to 78-677G, the board finds the following: that the proposed use will not adversely affect the health and safety of persons residing or working in the neighborhood of the proposed use, that the proposed use will not be detrimental to the public welfare or injurious to property or public improvements in the neighborhood, that the proposed use will not have an adverse effect on surrounding properties due to noise, vibration, odor, or glare effects, that satisfactory ingress and egress of the proposed use has been provided for, that the provisions of off-street parking have been arranged for, that provisions for proper utilities have been arranged for, any buffering, if deemed necessary, have been arranged for, signs, if any, and proposed exterior lighting are in harmony with the properties in the district. Any playgrounds, open spaces have been arranged for. Buildings and structures are acceptable, and the hours of operation are acceptable. That the following conditions are necessary. One, a major subdivision plat must be submitted, approved, recorded, and new pins assigned and reflected in the Buncombe County GIS prior to the site plan review applications. The plat must indicate a legally deeded easement connection to a private road and Waite Still Drive on pin number 9634-93-4059. The project must be constructed as depicted in the site plan, that prior to any land disturbance activity, the applicant shall submit a site development for a site development permit, and the site plan will depict the exact location of the buildings and accessory structures, the commercial lighting, any buffering, landscaping, and parking lot landscaping, any retaining walls. The plan must depict easements and right-of-ways, approved 911 or E911 road names, any other conditions by the Board of Adjustment, which there are none, a copy of any approved permits from the Army Corps of Engineers, Department of Transportation, or the NC Department of Environmental Quality where applicable, and that the master site plan permit approval shall not replace requirement of pulling an individual site plan permit for each building or structure within the development. And finally, that the applicant must agree in writing to these conditions prior to the commencement of work. Based on the foregoing findings of fact, the board makes the following conclusions: that the applicant's request for a special use permit with the inclusion of the necessary conditions incorporated herein meets each applicable requirement of the Buncombe County zoning ordinance, and therefore, based on the foregoing findings of fact and conclusions of law, the Board of Adjustment finds that the applicant is hereby granted a special use permit to establish a plan unit development on the property as requested, subject to the conditions referenced above, which are incorporated herein.
There's been an order presented. Is there board discussion on that or a motion?
I make a motion to approve the order.
There's a motion to approve in a second.
Second.
Okay, all those in favor, please say aye.
Aye.
Any opposed, nay? That passes. Thank you so much.
Thank you.
Now moving to ZPH 2025/00008 Asheville River Cabin Special Use Permit. We have Savannah Glantz from staff to present this one.
Please raise your right hand and state your name.
Savannah Glantz.
Do you swear or affirm to tell the truth and nothing but the truth?
I do.
Thank you.
Good afternoon. I certify that this public hearing was properly noticed and all applicable parties were notified of the meeting in accordance with the general statutes and county code, and I ask that all applicant and staff materials be accepted into the record as evidence.
Without objection, so admitted.
Thank you. This is the review of ZPH 2025-00008. Applicant is Brett Turner, who's the property owner. The property is located at 318 Wanderlust Ridge in Arden, North Carolina. The total acreage of the property is 8.72 acres, and it's serviced by public water and sewer. It is zoned PS and is partially in the floodplain. This special use permit is a permit for use, which is to allow weddings to take place on the property. Weddings or events would be classified under the zoning code as retail trade, commercial services, sales and rental of merchandise and equipment inside the building with no outside sales storage, which requires a special use permit in this zone district. In 2020, this parcel was rezoned from R1 to public service, and in 2021 was reviewed and approved as an existing travel trailer park. The applicant requests the allowance of weddings and events to take place, and again, this pre-existing travel trailer park, and all structures are on site. They are not proposing any new structures. Staff suggested conditions of approval. 1, if there are any on-site food preparations during the events, applicant must contact Alan Taylor with MSD pre-treatment. Events with more than 100 people shall require a special event permit from the Buncombe County Fire Marshal's Office. This is required due to access limitation, and it may require dedicated safety crowd managers as determined by the fire code official. Any tent over 800 square feet erected on the property shall require a permit from the Buncombe County Fire Marshal's Office, as stated in Chapter 1 of the NC Fire Code. And project must be constructed as depicted in the site plan. I did want to make a note for the proposed condition 5 concerning prior to commencement of land disturbing activity. Again, they're not just proposing anything new, but this is a standard comment that we put on all special use permits.
Questions for staff? Joel?
Yeah, you mentioned that, is the venue on the floodplain?
So the property is partially in the floodplain. I do believe some of the travel trailer units may be, but in terms of where the event could possibly take place, I would defer to the applicant. They're not proposing any new structures. So it may be that a tent could encroach, but I'm not able to confirm.
Okay, well, another question. Yeah, Kurt, something that's planned for a floodplain, is that under the purview of this board or no?
Not in terms of enforcing the floodplain. I think that if there was evident regarding health and safety, it might be something that you'd consider, but I don't believe at this point nothing like that has been presented.
Other questions for staff?
Yeah, one very, very minor question or point. When you were talking about serving food, you mentioned them having to contact a specific individual, and I was wondering if you would be willing or interested in removing the individual's name and just limit it to the department, because if that individual quit tomorrow, you know?
Yes, good point. That could be something that we could look at the conditions should this case be approved.
Okay. See no other questions?
Well, no, I have a question. It's just, I guess I'm looking at this and the site and how close it is to water, and I'm like thinking about, okay, food and toilets, and if you have a lot of people with a wedding, how are you going to control things getting into the river? And I don't know, do you think like everything that you put into the staff suggestions for conditions, do you think that that is enough to help control, things getting into the river that shouldn't be in the river?
I will say that our floodplain administrator, as well as environmental health, so that'd be septic, and MSD did review this, and these were the comments that they provided. So they would be the ones to review any type of waste management. And these are the conditions that they suggested.
Yeah, because it's not just the waste management, but it's also food, it's like, are they going to do food trucks or, you know, it's, they're gonna have outside, how are they gonna make it if it's like 100 people wedding? And then it's just huge. Yeah, I don't know. So that's, yeah. Okay, thanks.
Ms. Glantz, I just have one question regarding that condition. If there's on-site food preparation during events, the applicant must contact MSD pre-treatment. Do they need to get, not only do they need to contact MSD, but they need to get approval from MSD? Or is it that they just need to contact? I want to make sure we're clear on that condition.
Correct. I would say approval. This was a condition that was placed on by MSD, so really copy and paste, but I would add the approval there as well.
Okay. Other comments, questions for staff? Thank you so much. I believe we have Mr. Ost today. Is that right? Welcome, sir. How are you?
I'm fine, Mr. Chairman. Glad to be here. And with me here,
Hey,
Can you use
Bob,
the
Can
microphone,
you speak in
please?
that? Thanks.
sorry, and I'm a little bit hoarse because I've been getting over a cold, but please ask me to speak up if you can hear me. My name is Bob Ost. I'm here with the Asheville law firm McGuire Wood and Bissett. I worked with Brett Turner on completing the application. We can answer the questions that you had in a minute. We do have a presentation we'd like to run through real quickly. So if you need to swear, Mr.
We may
Turner.
want to have Mr. Turner swear in at this point. Yeah.
Please raise your right hand and state your name.
Brett Turner.
Do you swear or affirm to tell the truth and nothing but the truth?
I do.
Thank you.
Thank you. Good afternoon, Mr. Chairman, members of the Board of Adjustment. As I said, I'm Bob O's from McGuire Wood and Bissett, and we're here for the applicant for this special use permit. Mr. Turner is here with me. He is it's his LLC that owns the property and operates the facility. We'll have more about the facilities and the use in a moment. Also here is Murphy Fletcher sitting back there on the first row, who was here from our firm to observe. Before we get into what this is, I'd like to emphasize what it's not. It is not a wedding or event venue. It's not a bridal shop or showroom. What it is, and I want to be emphatic about this too, is that it's a beautiful setting that has now been greatly improved at no small expense by Mr. Turner and brought back to productive use. It's a perfect fit for the property. All that Asheville River Cabins, is the applicant here, wants to do is to make it possible for the guests of this facility to have weddings on the property there. The primary use is a travel trailer park, and it already exists. It's fully operational, and it has been fully operational for a couple of years. And all zoning and public safety requirements were met in obtaining that operational status. That is Asheville River Cabins, thought that a wedding was something that could occur on the property, and that it would be incidental and customary and incidental to the primary use. Staff disagreed with us. We met and discussed this, and staff suggested that a special use permit was the way to go for a commercial service. But it's not just any and all commercial services. The type of commercial service that we're seeking to engage in here is limited to weddings, and including ceremonies and receptions. But this is for guests of Asheville River Cabin. So it's not the typical kind of event or wedding venue. So here we are. We worked with the staff on this application in supporting materials and including some site visits. But as with any special use permit, we have to demonstrate that we meet several standards listed in the ordinance. You all have seen these things dozens of times. I'm not going to read through them here. And we'll present evidence, competent materials and substantial evidence on all of these standards, including the documents that have already been admitted into the record and the testimony of Mr. Turner, which we're about to get into. Staff has suggested some conditions. Those are in the staff report, and we're agreeable to those with one requested clarification that I'll get to when it gets down to a vote on this. And with that, unless there are any questions of me, I'd like to call Brett Turner, who will briefly explain the story of Asheville River Cabins and what he wants to do. Any questions of me? ahead, I guess you. Sure. I don't know where you all want me to be, so we can both be heard.
Hold on, why don't you talk?
Yeah.
I give you one of these microphones, and you can ask your question. You can either sit or stand, and then your witness can speak into the microphone.
Great, thank you. And we do have a short slide presentation. Can that be pulled up at some point? Would you state your name, please?
Brett Turner.
And what is your association with Asheville River Cabins?
I am the majority owner of 55 Parkway Lane LLC, which is the owner of the property.
Waiting for him to pull up the slide presentation that we've got. Okay.
Just have to scroll down.
Okay, thanks. What is Asheville River Cabins?
We call it a glamping resort, but essentially it's a travel trailer park, and all of our cabins are RV park models and/or Airstreams, and we're essentially a nightly rental. We operate like a hotel.
And how long have you been operating Asheville River Cabins?
Since 2021.
Okay, and how was the property used before?
It was a very rustic little cabin rental property. It had an owner's home and 6 old RV park models that are since gone and 1 double-wide mobile home.
Okay, and did you previously get the property rezoned to its current PS or public services status?
We did.
Okay, why was it necessary to do that?
We were told by the planning staff in order to expand the property to our current use, we needed to rezone to PS.
Okay, and since that time, would you briefly describe the improvements you've made to the property?
We've gone from the 6 original cabins to a total of 30 currently, with an ultimate build-out of 43. We have improved the amenities of the property. There's an old home on the property that is essentially operating like our community amenity now. We call it the River Lodge. We've added several different patios and community fire pit areas. We've essentially graded and re-landscaped the whole site and provided some of their common areas throughout.
And if we can figure out how to make this slide presentation advance, could you quickly run through
Right.
that and just?
This-
Apparently, yeah, so
Okay.
that's, I'm not going to ask you questions about each one of these, if you could just.
Do you want me to run
describe
through?
what these slides show.
So here's an aerial view of the property from the river.
And the property's on the left of that slide, right?
That's correct. You
Okay.
can see I think you can vaguely see it in that slide on the left.
Okay,
Previous use, as I said, was pretty rustic. There's just an old barn-type building, one of the rental properties. On the left is another one of the rental cabins that was on the river. To the right is the old owner home, which is now our community amenity. And this is what it looks like today. On the left are what we call looking glass cabins, which are a mobile RV park model in the floodplain that is a kind of a Scandinavian one-bedroom luxury glamping product. These are photos of what we now call the River Lodge. The old home was basically turned into a kind of a community open space. We've added the fire pit area that you see on the left. It's kind of a community fire pit area. Afternoons, on weekends, we open that up to the public and start a fire. We've got a little food truck up there, which is essentially just snacks, beer and wine, that we open up on weekends. Here's some photos of the cabins. This is our Riverview cabin type. All these sit up on the higher area of the site. And this is the site plan of the property.
Just stop there for right now. So, in response to a concern expressed by Ms. Morisani, and I'm sure held by some of the other board members, how do you deal with the potential for flooding on this, in this area?
For flooding of the cabins?
Of
So
the property?
everything within the floodplain is mobile. And we have an evacuation plan that's been presented to the county, which actually worked quite well during Hurricane Helene, but for the grandfathered in previous cabins that were there semi-permanent and really couldn't be moved. They were lost during the storm, but we were able to evacuate all of these mobile cabins within a pretty short period of time to avoid destruction during Hurricane Helene.
And back when this property was under development, did you spend any time with the county staff flood-proofing it in essence?
Well, we spent a good bit of time talking about development in the floodplain and all the various restrictions. We also got a floodplain permit, so we had to have an engineer look at everything in the floodplain and essentially draw up a permit that was approved by the county as part of the development approval.
All right, thank you. And so why are you seeking this special use permit?
Well, the county advised us that to hold weddings on site, that we would need a special use permit. This, as my attorney mentioned, this is something we were unaware of to begin with. The property had been doing weddings before I bought it, and we continued with that. I would comment that most of our wedding parties don't have a ceremony on site. Most of them are just parties that rent out cabins and then they have a wedding at the church down the road. But sometimes we do have parties that want to do a ceremony on site. And I know there was a question about that. So as you see the River Lodge there on the plan, it's on the over towards the right side. In front of that is a community green space right along the river. And that's typically where people want to have their ceremony, is on that grass field right in front of the river. There was also a question about food service and so forth and where that would be done. If you look at the road there, River Park Trail, which is between that community green space and our River Lodge facility, there's about a 12 to 14 foot change in elevation there. So everything that's at the River Lodge facility is up out of the floodplain. And as an aside, that was not even flooded during Hurricane Helene. So anything that we would do from a food service standpoint would be up outside of the floodplain in front of that River Lodge facility where you saw the photo of the community fire pit.
You've seen the application in this matter, of course, right?
I have, yes.
And did you participate in the preparation of it?
I did,
And is all of the information in that application true and accurate?
yes,
Okay, and does it contain a copy of the site plan?
it does,
And is the site plan accurate?
yes.
Okay. And is it your intent to limit wedding use to guests at Asheville River Cabins?
That's correct. We set a maximum number of 100 guests. Now, I will say that it's possible that there may be a few friends of people that aren't staying on the property, but that would be a very limited number and would be restricted by the additional parking we have. We have about 10 or 12 parking spaces beyond the parking spaces at the cabins themselves. So most of the guests that would be at the wedding would be staying on our property, which is a requirement. So that will handle almost all of the parking, but it's certainly possible there may be a few outside friends that drive in.
Now, is there any kind of an existing buffer between the property here and the adjacent residential property?
There is. I believe that was in the present.
We have some slides. If you
Okay.
scroll down, you can
Sure.
use that to explain it.
So behind us, up above the River Lodge facility, there is a residential subdivision. I believe it's called River Reach or something like that. And as you look at these slides, the wooded area is between us and that neighborhood. It's a pretty well-established wooded buffer that it has got very old, large trees in between us and that subdivision. I believe on the picture on the right, you can kind of see back behind there one of the homes in that neighborhood that are behind us. I think. Yeah.
So have you spoken with your neighbors about this, about your proposal?
I have. I sent a letter to all of the property owners that live adjacent to our property, just informing them of what we were doing. I offered to host a meeting at our River Lodge to answer any questions and gave them my phone number if anyone wanted to call me. We had 3 residents show up with a couple kids at that meeting that I held and answered all their questions, and I believe they were all in support.
And have you reviewed the conditions that have been recommended in the staff report?
Yes,
And are those agreeable to you?
they are.
That's all the questions I have, Mr. Turner. Thank you.
Any questions on the board? Paul, you had something?
No, I just have a comment. Thanks for doing the community meeting and addressing everything outside of this meeting. I appreciate that very much.
Paul?
If all of the buildings on your property were fully occupied, and I'll say parenthetically, because this is the reason I'm asking the question, and all of them attended a wedding, how many people would that be?
It depends. It would be a little over 100, because some of the cabins we have sleep 4, some sleep as many as 6. The cabins that sleep 6 would only be children. So from an adult standpoint, if you limited your question to just adults in the primary bedroom, that takes us up to about 90. If you included all the children in bunk beds and lofts that some of these cabins have, it probably steps up to 120-ish or more.
And are you planning on building any additional buildings?
No, we're not.
Okay, thank you.
I think it's time for us to move on.
Any other comments, questions? Hearing none, thank you so much.
Thank you.
Anyone else you'd like to call up, or if not, we can do a closing statement?
I have no further witnesses. The closing statement is pretty short. It's,
Hey, could you speak in the microphone?
sorry. First of all, we think that we have met our burden of production in this case and have been responsive to all of the standards that we're required to meet. And we'd ask that the board issue this special use permit. We're agreeable with the conditions, but I would like for the order to reflect that if the record doesn't already reflect that, I would like for whatever order is entered to reflect the fact that that as Mr. I can't see your name, I'm sorry. Mr. Mazzella has pointed out that we have no plans to build further structures, and the site plan is pretty much built out.
Okay, thank you for that. Anyone here to speak on this matter, on the Asheville Cabin Special Use Permit as a witness? Going once, going twice. Thanks so much. This time we'll close the public hearing and open up for board discussion, deliberation, and motion.
I think everything I was concerned about is addressed, and I'm okay to move to a motion if anybody else.
Yeah, the property is not being reconfigured, there's no new structures, it's a use piece.
Pretty straightforward.
Yeah, it is.
Do you have a motion sheet?
Absolutely agree, Andy.
I don't have one on me, so there's one there.
Paul?
Oh, yeah.
Yeah.
Mr. Chair, based on the evidence presented to this board, including the following exhibits, the petitioner's application, the submitted development plan, the GIS maps, the staff report, testimony presented at the hearing, I move that this board adopt the following findings of fact. That this matter was properly advertised, is within the board's jurisdiction, and is ripe for its consideration. That this application, together with the conditions proposed by staff and/or this board, and agreed to by the applicant, if any, does meet the requirements for granting a special use permit contained in the Buncombe County Code of Ordinances, Section 78-621 sub 3.
There's been a motion on findings of fact. Is there a second?
Second.
I hear a motion and a second. All those in favor, please say aye.
Aye.
Any opposed, nay? That passes.
Mr. Chair, based on the foregoing findings of fact and the reasons set forth therein, I move that the requested special use permit be approved and that the order approving the permit be adopted and executed as presented and as modified in this meeting.
There's been a motion to approve the special use permit. Is there a second?
Second.
Okay. All those in favor, please say aye.
Aye.
Any opposed, nay? Thank you. That passes. And we'll ask our attorney to go through a motion, order for us.
Yes, Mr. Chair, members of the board, I have the following proposed findings of fact for you regarding this order. This is based on the applicant Brian Turner at 55 Parkway Lane LLC for a special use permit to establish commercial services within the existing travel trailer park on PIN number 9635-62-9908. That's also known as 318 Wanderlust Ridge, which is the property. So the evidence here would be the staff report, supplemental documents, GIS maps, the application, applicant's exhibits, including the slideshow presentation that you saw, and any arguments advanced by the parties. The board makes the following findings, that the board has, that this was properly noticed and advertised, and the board has jurisdiction, that the property is to establish certain commercial services, which are weddings and events for guests of the travel trailer park, at 318 Wanderlust Ridge, that the property is located in a public service zoning district, that the applicant and other parties have been given an opportunity to be heard, and that pursuant to 78-677G of the Buncombe County zoning ordinance, the board makes the following findings: that the proposed use will not adversely affect the health and safety of persons residing or working in the neighborhood of the proposed use, that the proposed use will not be detrimental to the public welfare or injurious to the property or public improvements in the neighborhood, that the proposed use will not have an adverse effect on surrounding properties due to noise, vibration, odor, or glare effects, that satisfactory ingress and egress for the proposed use of the property and proposed structures has been provided, that provisions for off-street parking and loading areas where required have been arranged for, that provisions for adequate and proper utilities with reference to location, availability, and compatibility have been arranged for, provisions for buffering, if deemed necessary, have been arranged for, any signs, if necessary, and the proposed exterior lighting with reference to glare, traffic safety are in harmony with properties in the district. Playgrounds, open spaces, landscaping, access ways, and pedestrian ways with reference to location, size, and suitability have been arranged for. Buildings and structures with reference to location, size, and use are acceptable, and the hours of operation are acceptable. That the following conditions are necessary to ensure that the use will conform to the zoning ordinance. We've amended this from that, but it basically says if there's any on-site food preparation during events, the applicant must contact and receive approval from MSD pretreatment to review fats, oils, and grease conditions for the event. That this permit is only to conduct the following retail services: weddings or other events for guests staying at in the travel trailers. That events with more than 100 people shall require a special events permit from the Buncombe County Fire Marshal's office. That any tent over 800 square feet erected on the property shall require a permit from the Buncombe County Fire Marshal's office, as stated in Chapter 1 of the North Carolina Fire Code. The project must be constructed as depicted in the site plan. That prior to any land disturbing or construction activity, the applicant shall submit a site and development plan depicting the exact locations of buildings and accessories, a commercial lighting plan, buffering and landscaping, any retaining walls, easements, or right-of-ways on the property, the approved E911 road names, any other conditions, and a copy of any permits from the U.S. Army Corps of Engineers, North Carolina Department of Transportation, and the North Carolina Department of Environmental Quality. A master site plan permit approval shall not replace the requirement of pulling individual site plan permits for each building or structure within the development. The applicant must agree to these conditions in writing prior to commencement of work. Based on the foregoing findings of fact, the board makes the following conclusions: that the request for a special use permit, together with the imposition of the conditions necessary above, which are also incorporated, does meet the standards of the Buncombe County zoning ordinance. And based on the findings of fact and conclusions of law, the Buncombe County Board finds that the applicant is hereby granted a special use permit to establish a planned unit development on the property as requested to the conditions, based on the conditions incorporated.
There is an order before the board. Is there a motion?
I make a motion to approve the order.
Is there a second?
Second.
Okay. Motion and a second. All those in favor, please say aye.
Aye.
Any opposed, nay? Thank you. That passes.
Thank you.
Thank you. This time, the board will take a 10-minute break. Hello, welcome. Welcome, welcome, welcome. Welcome back. Welcome back. If conversations need to continue, please take them outside the room. Thank you so much. We'll come back to order and resume case ZPH 2025-00004, the Stern Stormwater Variance. This is continued from the June regular meeting of the board. And we'll ask Savannah Glantz and Victoria Hoyland to update us on where we are and to represent.
Griffin, should we go and just swear Victoria in?
And welcome back. Thank y'all.
Thank you for the clarification. All right, so good afternoon again. This is just a overview again of this case. This is ZPH 2025-00005. Applicants are Betsy and Alan Stern. This property is located off of Old Fort Road in Fairview. Total acreage is 10.1 acres. Property zoned open use, serviced by well and septic, is within the steep slope overlay, and the applicant requests the allowance of a driveway to encroach into the 30-foot stream vegetative setback. Again, I do have Victoria Hoyland with me, the stormwater engineer for the county, to further expound upon that.
Thank you.
All right, since it's been a month since we looked at this, I just want to give a brief refresher on the stormwater regulations, since I work with them every day, but you guys probably don't. So the vegetated setback is a requirement of the stormwater ordinance and state regulations. There are two different water quality standards that developments that disturb more than 1 acre must meet. And this development did disturb more than 1 acre, which is why it needs a stormwater permit. If a stormwater permit is not required, if the disturbance is less than 1 acre, then no vegetated setbacks are required from the stormwater ordinance because the stormwater ordinance does not apply. But it applies in this case because they disturbed more than 1 acre. If the project meets low density standards, then no built upon area is allowed within the vegetated setback. 30 feet from the top of bank of the stream, there's no built upon area allowed. Built upon area is essentially synonymous with impervious area. So gravel roads, concrete, asphalt, buildings, all of that is impervious area. A gravel driveway is considered impervious area. So for low density development, no built upon area is allowed within that setback. It must remain vegetated. For high density development, under state law, built upon area is allowed within the setback. It's not recommended, but it is permissible if the entire site meets high density water quality standards, which requires treatment of all runoff from the net added impervious area, and specifically the runoff from the impervious area or built upon area within the setback is treated before it is discharged into the stream. And it has to be discharged through a portion of the setback, but that's a nuance that is not really relevant here. Trying to think if there's any other context. So I guess the question here is, the site is seeking to meet low density water quality standards, but still wants this driveway, which is impervious area, to be located in the setback without providing the full treatment that's required for high density regulations. And that's the question at hand, is the variance is allowing that and built upon area within the setback without meeting the high density standards that would otherwise allow that.
And that was their position at the initial application period, has there been communications in the past month with staff that would change that?
I have not had any communication with anyone on this project since.
We'll hear more about that, but want to check with you. Yeah.
Do you have a Reader's Digest answer to what is treatment?
Yes, so treatment is where the water passes through what's called a primary stormwater control measure. And there are lots of different types of stormwater control measures that qualify as a primary measure. Bioretention cells, you may have seen them around town. The water goes in, there's plants and media, and pollutants are filtered out. Other examples are sand filters where the water passes through sand, the infiltration systems where the water just infiltrates into the ground and is not discharged. wet ponds, which are kind of the bigger ones that you're used to seeing at larger apartment complexes and commercial developments. It provides the standard used to be that it provides an 85% reduction in total suspended solids. So it removes the suspended solids from the stormwater runoff so it doesn't get into the creeks and streams. The new standard it's a little different, but the intent is to remove that sediment. To some degree, they also remove nitrogen and phosphorus, but we don't really worry about that out here yet.
Do any of those measures have an impact on water flow rate? Can it make the water move faster, or does it?
So the water flow rate question, or this requirement, is the same in high-density and low-density projects. They must provide peak flow attenuation per the ordinance. They must provide peak flow attenuation for the 1-year, 24-hour storm. So that means that for this specific design storm, the 1-year, 24-hour storm, that the peak flow rate post-development cannot be higher than the peak flow rate pre-development. And so, no, there's no standard that must be met that these primary stormwater control measures meet that, non-primary stormwater control measures do not meet. Some stormwater control measures are much better at providing peak flow attenuation than others. Obviously, infiltration, there's no discharge until you get to a certain level of storm, and others, it just passes right through, so.
And obviously, it's the applicant's choice on either of those directions they want to move, but in staff's opinion, with knowing the site parameters here, the topography, the fact that this is located on the right-hand side of the plat, close to the edge, does the applicant have room for those measures in staff's opinion, or any of the, one of those three measures?
So I think that the site could meet high-density regulations overall. Specifically in this area, they would probably require some consultation with manufacturers of some proprietary products to work, or consultation with the attorney to see what the restrictions are within the existing right-of-way and easement. There are certain types of stormwater control measures that function largely like a pipe. And so, could those be installed in this area under the restrictions of the existing access easement and right-of-way? Maybe, but I am not an attorney and have not reviewed that. Is it possible that they cannot? That's possible. The slope of the driveway may also prevent certain types of stormwater control measures from being feasible. There's no really obvious, clear solution that would allow them to provide the treatment required. That's not to say that there isn't a solution, it's just not one that is readily obvious. It would require some additional questions to be answered.
Other questions, comments for staff?
Yeah, and then Savannah, did you have any correspondence with them, any change in position or any options reviewed? Okay, thanks.
Do you want me to? So just to clarify, the difference between the high density and low density treatment, though, does not relate to the stability of the road. The stability of the road is outside of the purview of the stormwater ordinance, which is what this variance is asking about, just to clarify.
The stability of the new road?
The stability of the driveway in question in the buffer is not within the purview of the stormwater management ordinance.
Okay. Other questions, thoughts? Thank you all so much. We appreciate it. And we had our other parties withstanding, right? Yeah. Let's come on up and grab your favorite seat. We did turn the microphones on earlier, make sure they're tested and on. And we were about to start your presentation, Mr. Golden, is that right?
No, I think.
Last time?
I think we testified for 2 hours last month and finished our evidence, if I'm.
Yeah, I remember it was.
It was,
long,
I mean,
but-
yeah, I mean, it was 2 hours, right?
Yeah.
A lot of cross-examination, but I think we did complete our evidence, closed our case, and the other individuals withstanding were gonna call their first witnesses.
Right.
But I think it ran
Ran
right
over.
up to 4.
That's right.
If the board would want me to represent anything, I'm happy to do that, but I don't want to delay this.
I just have a question. Did you guys have meet and come up with different options or have any meeting of the minds from the
So-
last meeting to this one?
So what I will say, my client is absent today, so I'm gonna start with that, and for that, I apologize. There was some miscommunications or misunderstandings on my part. When I received an email from Buncombe County that asked me to look at August for this date, a couple of days after that, and it wasn't, so a couple of days after that, they clarified and said, sorry, July. And I had told my client August, he had scheduled a travel trip for his work that he couldn't get out of when 9 days later I said, oh, sorry, it's back on July. So he's not here for that reason. He did send me a letter that Mr. Wilkie did send him indicating that Mr. Wilkie hasn't had enough time, and I don't want to speak for you, but that he didn't have enough time to investigate where a new roadway would go. Mr. Wilkie asked my client, and there's a certified letter or a notarized letter from Mr. Wilkie asking us to continue this matter until a later time so he could have time to investigate where the road would need to go. But my client just asked us to pursue the variance that we started in June and finish it up today.
And so, but today, are you in a position with his consent or communication remotely to be able to have him agree to conditions, supposing that we get that far in the process and get to approval if we get there? Is he able to consent remotely?
Oh,
to
yeah.
conditions?
So he's watching remotely right now.
Yeah.
My client is. So
He
I
can-
could
he
call
can
him
confirm.
up and get his approval on conditions. Yes.
Perfect.
Mr. Chair, can I ask you
Please.
one quick thing for the edification of all the people in the audience? Could you very briefly describe to them standing versus witnesses?
Sure, we went through, just so everybody's here, if they're new to the hearing this month, just a brief description. Standing involves, well, I may actually have Kurt go through this because I enjoy doing it, but Kurt just gives some more eloquent description of this here. But go ahead and describe, standing.
So what the difference is between a witness is that you are just giving testimony. A witness would just be giving testimony based on their personal knowledge of what they are testifying to. A person that has standing is actually kind of like a party to this hearing, right? So a standing applicant has the right to cross-examine the opponent's witnesses. A standing applicant has a right to present evidence and present their own witnesses and ask questions. In a sense, the people with standing are acting in a pro se or representing themselves versus having an attorney do it. So a person with standing is more or less acting as a participant, whereas a witness is just basically giving testimony based on their personal knowledge. They don't have a right to cross-examine witnesses. A witness also does not really have the right to put on a full-scale presentation. They are merely there to answer, to give their statement. And that statement, since it's a quasi-judicial hearing, needs to be based on personal knowledge and the facts at hand. And so if you're giving an opinion about traffic or giving an opinion about safety or anything like that, you would probably need to somehow explain how you're qualified to give such an opinion.
That's about right, yeah. And the board also has requirements with which to measure or weigh expert testimony. We did receive a lot of that, of course, from the applicant and their professionals, of course. But if it's about traffic, it's about appraisal, home values, whatever, those are all from professionals and would need to be expert testimony. And standing, folks who have standing can present that, of course. If you're a witness speaking later on in the procedure as a lay testimony,
Right.
and you would have that weight, which is a lesser weight than a person with standing.
Right, and I think the only other thing is that in order to be granted standing to participate in the hearing, you have to show that there are some special damages to you and your property that are unique from the community at large. So I think that's
Right.
another special thing, that there's that added hurdle that needs to be reached.
Right, that's right. So we're through that process now, and then we're going to hear from witnesses later on in this process. So
Yes.
there'll be a time if you want to speak to be recognized. Mr. Wilkie or Mr. Maselli, either one of you want to go first here?
Sure.
Yeah, please speak in the microphone.
One of my primary, is it
You're on.
coming through? One of my primary concerns from the outset was the fact that I've very clearly recall offering an alternative route that would have kept him far away from any stream and that could cause any damage. Mr. Stern did not remember that offering or any subsequent meetings related to that. So today, I guess the first thing I would like to do, I have asked somebody to take off work, and they are here, and they were in that meeting. They met with Mr. Stern at Mr. Stern's request. Mr. Stern then asked me to meet with them to show them where I would propose an alternate road that would stay away from the stream, and I did that. And then these individuals went back to Mr. Stern and told him, according to what they told me, they told him it would be a better path. So in the application for a variance, I do want to say that I object to the fact that the statement said that there was no other access to the property, and the adjoining property owner, which was me, would not give him any other access. That access was given. And I would ask that Mr. David Mount, who was contacted by Mr. Stern, Mr. Mount subsequently met with me and then reported back to Mr. Stern, that this would be a better road driveway than what he has ended up with. Excuse me, drawing a blank. Oh, also in the letter that during our last meeting, at the conclusion, you suggested that we try to work this out, that we have dialogue. I opened that dialogue with Mr. Stern by sending a certified letter to him, telling him that we were reaching out to engineers. We're on the second engineering company, and they tell us it will still be it will be 6 weeks before they can get the route mapped out. And we, at the attorney's suggestion, we are incurring that expense. So two things I'm asking for today is to please hear the witness and also give us time to get a map, a surveyed map, and from an engineer of an appropriate road that would have no additional impact on the streams. So first, I guess, so that this guy can go back to work, I would ask that you hear the witness, if that's possible.
Sure, that's possible. Yeah, let's go ahead and hear you.
So I just want to be sure, were you asking for a continuance to continue this matter until you get something back from your
From an engineer, we are hiring an engineering company to confirm what Mr. Mounts has stated, that this would be an appropriate driveway.
The one that's proposed in the variance application, not the ones we considered at the other parts of the property or it going over the stream.
This is a new,
A new one, okay.
it's the one that I offered a
Yes.
couple of years ago, but was not on record and was denied that it was offered.
So no is the answer, I think.
So there is no motion to continue?
No.
Okay.
Yeah. Welcome, sir. How are you?
I'm good. How about you guys?
Doing great. We'll swear you in.
Yes.
Please raise your right hand and state your name.
Paul David Mount?
Do you swear or affirm to tell the truth and nothing but the truth?
Yes.
Thank you.
And we would, in anticipation of what his testimony is going to be, we would just offer an objection for the record, as it's not relevant to the standards that are set forth, to grant a variance.
If you can make it after he speaks, that would be wonderful, actually. Yes, sir. How are you?
I'm doing great. So to my understanding,
So let's make sure that we handle this properly. Mr. Wilkie, you need to ask questions of the witness. so that,
Rather than
you
him
know,
presenting
we're
something.
not going to ask the questions for you. So you, as a person withstanding, you can ask the questions of the witness.
To get the information you need out of him. Yeah.
Okay. Mr. Mount, were you contacted in November or December of '23, approximately 2.5 years ago now, by Mr. Al Stern?
Yes.
What was that discussion, if you could describe it for us?
Well, the discussion was to have a meeting with you, Mr. Wilkie, and Keith Florence, and his builder, I think at the time. I do not remember that gentleman's name. To look at putting a road in across your property to his property.
And this was an alternate road, not the one that went through the gate, that was the deeded easement?
Correct. Correct. This is off the main road there. If I remember correctly, again, like you said, it's been 2.5 years ago. It was to the left of the main road, and it went up the ravine to the left.
Well, I believe when we met, there were two possibilities. One was
Yes.
going up the ravine, but another one,
And I'll,
Hold on.
yeah,
Yeah.
I would just object to him
Yeah, yeah.
testifying
Well, and I-
at this point. He has plenty of
Okay.
opportunity to get up there.
Right,
I
Mr. Wilkie,
apologize. I agree.
just to make sure, yeah, there's
I
a difference
apologize.
between you testifying yourself as opposed to asking questions. So when you've called a witness, you need to ask the questions of the witnesses, then you can call yourself as a witness and testify and make whatever statements you wish to make.
And while you're formulating, sir, can you remind the board of your name and company?
Paul David Mount, and the company that I was meeting with a friend of mine, it's K&M Excavating. We do the larger jobs together.
Thank you, sir.
And just moving forward, I apologize, we would just object because as Mr. Mount said, he doesn't remember, or it's hard for him to remember, but just for the record, I want to raise that objection, and I don't think it's relevant, related to the 4 standards set forth in the Buncombe County ordinance related to the stormwater variance.
And the objection is that he's not a qualified expert, is that right?
That is correct.
Okay, thank you, yeah.
okay.
Noted.
Mr. Mount, do you recall that there were 2 potential additional
Yes.
driveway sites?
Yes.
In approximation, I believe the first one off of Old Fort Road was approximately 100 to 150
Well,
yards.
I'm going to object
Yeah.
again. He can testify
Okay.
all he wants when he gets up there, but if you,
Yeah.
I would just object. He's leading the witness and he's not asking
Yeah, ask about
appropriate
the length
questions.
without giving the length.
Can you describe the approximate location of the 2?
Yeah, they was 2 different locations that the road could have went up. One was closer to the main road that went up the edge of the ravine. The other was farther up the road, somewhere between 150, 200 foot, off of Old Fort Road, and would come up more the ridge line, up the mountain. And, so those was the 2 options that we gave him.
Did you feel, by comparison, do you feel like one of those options would have been better than the existing one through the
Oh,
easement?
most definitely.
And
Most
we'll
definitely.
we'll object because he hasn't established a foundation to give any opinion testimony as to what his background, training, and education and experience is.
42 years.
We're not
working in
taking,
these
yeah, we're not
mountains.
taking it as expert testimony at this time. The board's interested in the conversations that y'all had prior to getting here today in the past on which routes were
So,
possibilities. We've
Mr.
heard from your client, though. I mean,
Yeah,
through
Mr.
you.
Wilkie, once again, and if you were going to be asking any witness of an opinion, you need to establish, you know, what their qualifications are as to why they can give that opinion. All right, so you may want to, so I'm just trying to say that's why there's the objection, okay?
Mr. Mount, how long have you been a grading contractor?
Me personally, 42 years I've worked in these mountains. It's been a family business since 1942.
So your father was in it, you grew up in the business, is that what you're saying?
That's correct, yes.
Have you ever put in a driveway up a mountain?
Yes, several. Probably several hundred, to be exact.
Okay. Dozens, if not hundreds, is that what
Yes,
you're saying?
Correct.
Did you see any particularly difficult challenges to the driveway option that was offered?
No, neither one of the two options that we give Mr. Stern would have been difficult, by no means.
Was there a better, of those two options, was one better than the other?
Not really. Honestly, they both was good options. But no, if I was to make the choice, it wouldn't have really, you could have flipped a coin. It's 50-50. Both was really good options, a lot better than the option of going across the deeded right-of-way.
So by your testimony today, you were telling me that Mr. Stern did reach out to you and ask you to contact me to look at these two options that I had proposed. Is that?
That's correct, yes.
And then you and I did meet, is that correct?
That's correct, yes.
And subsequent to our meeting to look at those two driveway options, did you report back to Mr. Stern?
Yes, yes.
And what did you tell him?
Well, I told him that the option we give him was the road up the ravine, was the price that we give him for that, was going up the side of the ravine, up the mountain there, closest to the dirt road, not Old Fort Road. And that was the option that we priced because he felt like that would be a better choice for him.
So if for clarification, going up the ravine would be further away from Old Fort Road
Yes.
than the other one?
Yes.
Are you confident you could put a driveway up that ravine?
Oh, most definitely. Yes, sir.
Are you confident that you could put a driveway in if you took the one closer to Old Fort Road? Are you confident you
Yes.
could put that in?
Yes.
Have you put in many driveways with similar terrain that were
Yes.
as difficult as?
Similar or worse.
Are those driveways still holding up today?
Yes.
To your knowledge?
Yes.
I guess I have no further questions.
Okay.
Thank you, sir. Appreciate that.
I'm
Mr.
sorry.
Maselli, do you have a cross?
Do you have any questions for?
No questions.
Thank you. Mr. Goulden, any cross?
Dealing with installation of driveways for over 42 years, you understand that a deeded access to a piece of property is the expectation that a driveway will be built in that location.
No, I don't feel like it's an expectation when you have other options.
All right. And so you understand that there is one deeded access to my client, Mr. Stern's property that runs parallel to Mr. Wilkie's property.
Yes, I understand that, yes.
And you understand that Mr. Wilkie's property, or Mr. Wilkie's access and driveway is also within 30 feet of the creek that runs through the middle of those two accesses.
Yes.
All right, those would be my questions.
May I actually counter or cross
We've
and ask a question
we've passed
based on the attorney's questions?
Yeah, we'll do a counter cross. Yeah, let's do a rebuttal. Yeah.
Okay, rebuttal. Thank you. In your discussions with Mr. Wilkie, did he mention his willingness to offer an additional right-of-way?
Yes, he did.
Thank you. No further questions.
Thank you, sir. Board questions?
So in your perspective, are you able to address Victoria's issues with the trout stream with your solution? With both of your solutions?
Yes, it would, yeah. It would not affect the trout stream whatsoever if it's done right.
The one
then-
that's proposed, the current
The
driveway.
two that are proposed?
The two that I looked at,
The ravine, yeah.
yeah, no, I'm not commenting on the road that's already there. I've not seen what's there.
And I guess I'm just going to object. I haven't seen where any of these are proposed. There's been no identification of where they're proposed.
there's no
There's no
map.
location. There's no there's no deeded easement across Mr. Wilkie's property other than what was shown on the survey.
That's
And
because.
so I think when we're talking about this one, is it better than this one? We have no idea where it is, and there is no easement. And so we're just going to raise an objection to the ongoing questioning about these two proposed locations.
And I can understand that because Mr. Stern chose not to take our options.
So here's a question here. There's a sliver to the southeast corner of the property on the road, the main driveway that does touch this property. Is that access, it's a steep one there, but is that access one that you looked at all as a third option?
Is this the map here, I'm supposing?
Comes in a semicircle there?
Is that the one they're talking about?
Mr. Golden, is there a map that we can put up that maybe might help?
Yes, I can put up the plat and expand it if I can unplug this and plug mine in.
Would that would be okay?
Could I
Yeah.
do that?
Yeah, I
Just
think
a-
that,
That's fine.
I think that might be helpful for everybody to at least have a map and
Okay.
try to at least establish what we're talking about.
Yeah, let me see. And then you'll be able to see it right here.
Okay.
Yeah.
There isn't, because we're only talking about the wetlands area, wetlands issue. He's not somebody who can weigh in on that.
All right, now I'm going to blow it up for you so
Okay.
that you can look.
Yeah, because old people can't see.
Yeah. Yeah, and Mr.
If he agrees that the guy can go.
Ball, I think that's about right. He was
I'm
asking.
sorry.
So here's what it's, this is where he was asking about right there. And so, Chairman Ball, if you want to ask the question again, I just pointed out to the witness where you were asking about.
Right, thank you. So we understand, let me recap the question here. We understand that the deeded access proposed on this map, coming to that semicircle and continuing on to the left-hand side of the property where the house is proposed to be built is the deeded right-of-way. We understand that. That's the primary access we've been talking about the whole time. Then there's been a discussion on the left-hand side of the property, not depicted here at all, but coming from the left-hand parcel, it's not even outlined here, coming onto the property from the bottom left, that's the second, straight up the hill, if you will, proposal that you talked about with him and did not get numbers on, right?
Here, let me scroll down. So this is,
Do you have a map with contour lines?
Yeah, GIS might even be better than this.
Yeah, that would. be
Yeah,
great.
GIS, I think.
Contour lines that way.
yeah, hold on,
Brian, thank
since
you
I've
so-
got it plugged up, let me just pull up.
Thank you, Brian.
Let me just find it. Okay.
Yeah, it's better.
Is it, now,
That's
and
what we had, but
I'm
that's
happy
fine.
to expand in wherever we wanted to,
Okay.
so if you're talking about right there, Mr.
Yeah, that's
Chairman.
I was going through all three of them, but I guess if you'll zoom out again to where the house was. Yeah. On the left-hand side of this property, the parcel's not highlighted, of course, it's a plat, but to the left-hand side where the house is proposed, there's a discussion of going straight up the hill for possible driveway
Well, you
access.
would go straight, excuse me.
Well, or-
I didn't mean to cut you off.
Or up from the main, up from
Yeah,
Old Fort Road.
up from the main
to
road.
that.
You would have, some switchbacks.
You would.
To get up the slope.
But that's the second option you talked about with him and did not pursue as far as getting into numbers because he elected to go with this deeded one, right?
Yes.
And when you said better, a better choice in your opinion, was that based on cost or was it based on something else?
It was based on basically getting away from the stream and you could lessen the grade on it, so it wouldn't be as steep.
And lastly, the third I mentioned here, the bottom right portion where this property does touch the driveway again, lower down, that does provide legal access onto this property, of course. It's quite challenging, of course.
Yes.
Was that discussed at all or thought about it at all or just discarded right away, pretty much?
That's okay. No, it was discussed, but again, we took it, he didn't take it any farther than that, any farther than just discussing it.
Okay, thank you, sir. Questions from the board?
Could you expound upon that? Did he give you any explanation for why he came to the decision to not
No,
accept the
sir.
alternatives?
No, sir, I met with them that day. We priced the job of going more to the right than what we just discussed, and never heard back from him. So I guess he didn't like our price.
Okay.
That's, yeah, you don't know.
Other questions?
Did you reference a gate?
No, the attorney, or Mr. Wilkie did, someone, Mr. Wilkie. That's the gate, if I'm not mistaken, on the deeded right-of-way, if I'm not mistaken.
Right.
Okay. Thank you, sir. I think that's all we have for you. Appreciate it.
Thank you, guys. Have a
Yeah,
good
when you get back to work, tell them this was part of your work.
Well, sorry I come so dirty, guys.
Thanks so much, sir.
Mr. Goulden, do you have any problem with excusing this witness?
I do not.
Okay, thank you.
And just to clarify, Mr. Wilkie, again, on that conversation you've been referencing several times between the parties here, did you intend to offer your parcel that's long and skinny on the left-hand side of this property, the west side, at any cost to him or not? Or was it free?
It was offered at no cost.
Okay.
I would just move the easement from where it is to wherever was best for Mr. Stern.
Okay.
Whatever option he wanted to do down there, I offered to him.
Okay. Any other board questions for Mr. Wilkie?
Hold on, yeah, Mr.
sorry.
Well, I would suggest that at this point, Mr. Wilkie, do you want to testify or give your statement or whatever you want to do regarding this? Because so like you would basically go up and give your statement or present any information that you want. You can do that, or you can also call any other witnesses if you have any other witnesses that you want to present.
I would like to give a statement. Okay.
If you could just go up to the podium and then give your statement. Thank you. And I believe he's been sworn? Okay.
Yeah.
I'm trying to remember. I am remembering to the best of my ability what happened about 3 years ago when all this started. Al Stern and I had several conversations, and I did offer my driveway as it comes off of Old Fort Road splits the lower 10 acres that I own down there with approximately 4 acres, I'm guessing, to the left side and 6 acres to the right side of that main driveway. That 4 acres to the left is of no use to me. It's not where I would build a house. And I offered Al Stern any part of that to the left of my driveway from there all the way up to where his lot connects to the road. I offered that to him at no charge. I offered it to him as an exchange in easements. And I'm sure we had other conversations, but grading began, I believe, in the spring of, 23 or 24. That should be a time that would be easily nailed down, but off the top of my head, I can't remember it. I think it was about 2 years ago now that the grading did happen, and it did begin in June without any silt fencing, without any precautions whatsoever. Machines showed up and started grading the property. Gosh, I'm sure there's more I want to say.
I have a question.
Yes, Catherine?
I guess where I'm really troubled is why aren't you working with your neighbor on the legal easement that's already there to fulfill you know, with that, you both have to be there, you're both neighbors. Why aren't you working together to come to what is already there legally versus making him go build somewhere where you have no use for the land? He's gonna have to do all this work. Why can't you guys just come together and work out something that is beneficial to all? And so tell me, like in the last month, I asked you guys last month to think about different options. And so what other options that would be, you know, win, given what is already there? Why are we having to make it so difficult, I guess is my thing. And what options did you think about from the last month to this month that could be better?
Well, after the meeting last month, we did have a conversation, and Mr. Stern's attorney suggested that we pay for the bill for getting a new route designed, and I have been working on that. I and members of the Echo Lake, because all of us are concerned about the existing easement, the one that is currently in place. It is much higher. My private road, my private driveway does border the stream on the other side, but it's not way up in the air above the stream like Mr. Stearns is. We are very concerned about erosion that is occurring right now. The silt fences have not been maintained. It was a grading permit. This all happened. I thought Al and I were talking back.
If you're concerned about it, then why aren't you addressing it yourself? Because it's your property.
Why am I?
Not addressing it yourself if you're concerned about the problems that are already there, because it's your property. Why aren't you fixing it?
So again, the public.
Hold on, please. If you are in the audience, please do not interrupt the proceedings unless you are speaking as a witness. Thank you.
Thank you.
I don't know what to do. No permit was taken out. I have talked to.
That's not my question. My question is what are you doing to work with your neighbor to work toward a solution? And then second, if you're concerned about runoff and it's on your property, why aren't you fixing it? I don't care about the permit. That's not part of my question.
I feel like I am working with him because I have offered him free, unfettered use of the 4 acres to put in a separate driveway. That would be much better for him. The one that he has built faces north. This one faces south. This would be much less steep than the one. So I am working with him. I've reached out to engineers and am willing to grant a new deeded right-of-way, which was offered, and I don't understand why it wasn't taken.
Well, it's not taken because it's your idea of what's right versus what's his. How are you two working together to come to a collaboration?
Well, it's not just my idea of what's better.
Yeah, if he's not taking it, then it's not acceptable. So how are you collaborating to figure out a solution for everybody's win? So everybody wins.
Well, I think everybody would win if he would choose.
No, it's not if we. Where's the we in this? I'm not hearing the we.
I see we all around us.
Hold on.
Mr. Stern has not responded to my letter. I thought we had an understanding when we left the meeting last time that if that offer was there, that I should hire an engineer, and we're moving forward in that direction. I have sent a letter to him, letting him know that I am doing what they suggested immediately following the last meeting.
Okay. Other questions from the board? Joel had something.
I got a couple questions. Just to clarify, you're not here seeking a special use permit, right?
Correct.
Okay, I just want to
Yes, he's not the
clarify that.
Yeah.
Okay. The other question I have, you say two options were presented. Okay, since the last meeting, has Mr. Stern been aware of these two options?
Well, I'm just going to object to that because that would call for his speculation as to what the two options are. Mr. Stern already testified at the other hearing about what he
Yeah.
recalls that conversation was.
Joel, I don't think that we should be asking that witness about what Mr. Stern does or doesn't know.
But ask him about what, his actions are fine, you know.
I did send a letter to him, and it was certified, and the U.S. Postal Service has confirmed that he received my letter.
Okay, did you get any response from him?
None.
Okay, because I'm trying to look for a mutual solution. That's my feeling being on the board. Okay, so you didn't get any response from him as to whatever the options were. You say presented two. I'm not looking into technical details, but basically I'm saying, you know, the question is, who's working here in good faith to try to resolve this? Okay? That's my feeling right now. So basically, is it your feeling that Mr. Stern is not working in good faith to try to resolve this?
I'm going to object to that. It calls for him to speculate as to Mr. Stern's good faith and
We'll
the question.
we'll sustain that. Can we rephrase that, Joel? in
Or
terms
can
of-
I ask him his opinion or no?
Well, I don't think you can ask him.
Not on that
I don't
subject.
think you can ask him Mr. Wilkie's opinion on Mr. Stern,
His
or whether
intent,
whether Mr. Stern is acting in good faith. I don't think he can do, I think you can
Joel.
ask him, did Mr. Stern respond to your letter or not? But I think that trying to imply or trying to, it would probably be a more appropriate a question for Mr. Stern.
May I make a statement?
Please.
At the end of the last meeting, we did have a conversation, and it was suggested that I hire an engineer and map out an alternate route across my property to his house site. I initially thought that the engineering expense was unreasonable, but I changed my mind, and I let him know by way of letter that I would absorb that cost. And I was proceeding with having an engineer design a new route to his property that would not require any variance that I'm aware of. It would be less steep. There would not be a 30-foot tall bank on a 1812 pitch. None of that would happen if he chose the route that I am currently pursuing, and which is also, in my opinion, the best route to his property, and it was offered 3 years ago.
And we'll object to him without any foundation testifying about what's the best route to Mr. Stern's property.
Sustained, and we're going to pause Joel for a minute. You can come back with some more questions in a minute, Joel.
I got one
Craig,
last question.
one more. Joel, if you'll hold off. Craig, next.
Oh, are you going to admit the letter that you referenced as evidence or as an exhibit?
Are you referring to the letter I sent to Mr. Stern?
Do you believe that it's of value for us to see this letter?
Yes, I did bring a copy of that today.
Are you going to admit it?
May I?
It can be admitted at this time, yeah. If you'll pass one to Mr. Golden.
Before it's admitted, please share a copy with Mr. Golden and let him.
I've got 10 copies that I can hand out to the board because I anticipated that they were going to introduce the letter. So I'm happy to hand them out on his behalf, and I've got it pulled up on the screen.
Thank you very much. That is very kind of you.
And we're all sure that this is the same document,
Yeah,
correct?
can you hand one to Mr. Wilkie so we
let
can
me
compare
just
it?
make sure that he agrees that that's the letter he sent.
I mean, he can look on the screen and see if that's the letter. Can you see it right there?
All right.
It's not a substitute letter, Mr. Golden, I guess.
This is better.
Is that the letter you're talking about?
Oh.
At the bottom?
Yes, that's the letter.
Thank you. Thank you. Do it again.
Mr. Golden, do you have an objection to this letter being admitted to the record?
No, I do not.
Thank you.
You're welcome.
Any objection, Mr. Maselli?
No objection.
Thank you. Did you have a follow-up on that one, on the question?
And did you say that there was no response to this letter, or there was?
I have not received a response.
Okay.
Great, thank you.
Anybody else with a question over here?
Yeah, well, I'm just seeing that there's kind of, I'm not seeing like a real plan. So is there like a map or other?
Well, as is referenced in the letter, we're working on that. It can't happen overnight. As a matter of fact, our latest estimate right now is 6 weeks from now for the engineer to get that together.
Joe?
Yeah, I just want to clarify, because one of the other board members asked, not the options, but the current right-of-way, that's deeded to you. You own that right-of-way, or the original proposal is?
I own the land,
Granted.
and Mr. Stern owns the right-of-way, or the easement. I mean, I think that's the way it works.
Okay, so who owns the easement, the current easement? Is it
Mr. Stern?
Mr. Stern has an easement across my property.
Okay. Okay, so you got an easement, okay. So are you responsible for fixing something on that easement?
That's a legal question I'm not sure I can answer. I believe that because it is on my land, I could be responsible. Most of the grading has occurred off of my land, and I don't really know what my rights are, even on my own land where that easement is. I don't know what I can do. I know that
Well, have you ever been approached by any regulatory agencies saying you got to do something as a result of that right-of-way there?
I have talked to I've communicated with regulatory agencies, Buncombe County Erosion. They are dealing directly with Mr. Stern on this because it is of his making, and they understand that.
Okay, thank you.
Yes, Paul?
Why do you consider it in your interest to switch the easements?
I actually think it would have been better for him in many ways. For me, it is,
The question is about you, so can you focus it on you, not him, please?
sure. I am concerned. I mean, I admit that I feel like I've got PTSD, especially after Helene. There is a vast amount of erosion coming down the grading that he has had performed. The silt fences are not being maintained. It's my understanding that he's receiving daily fines and nothing's being done about it. I don't know what my rights are. I honestly do not. I'm pretty sure I don't have a right to go on his property and start putting up taking care of silt fencing. And it is my understanding that the erosion control people are dealing with him, and I truly don't know what I'm doing, or what I should be doing that I'm not. I'm offering something that most people that are familiar with grading would agree is a better option for
Well,
Mr. Stern.
Objection, just.
Please,
call.
like, focus on you.
You agree, yeah?
Okay. Repeat any question you have for me.
Okay. Any other questions the board has?
I guess
I-
I agree with Paul. I really am not understanding how it, the easement's already there. The easement's been there, like, since the 90s, right? 80s, 90s?
90s, yeah. Yeah.
And it's just like, why can't we work with what we already have? Instead of cutting new ground, excavating new ground, doing, why can't we just work with what we have? And why can't you, you and your neighbor can't come to an agreement on how to work with what we have?
Just a point of order real quick. It's not up to Mr. Wilkie how the applicant, in this case, accesses the property. So there's a legal access currently and a right-of-way currently, and that's what's before the board today in our final ruling. Other possible routes are
I think that
being talked about, but they're not particularly
I think
pertinent
that-
to our decision today.
Well, I think the question that you all, where all this is going is this a self-created hardship in terms of?
Right.
Is the variance necessary based on a self-created hardship?
And
whether
the board needs to find that.
But that's something that you're going to have to
Right.
deliberate the evidence about.
Right.
I guess to partially,
1 second, sir. Paul?
I'm going to admit in advance that I'm going to try to lead you on this question, okay? Would it be correct to say that prior to any construction on the area of the current easement, that you have no particular problem with the easement? Looked like 5 years ago, the easement existed, but there wasn't any road built on it yet, right?
that is correct. I will tell you that it was always very mysterious to me, and I'm a grading contractor as well. It was mysterious to me how a decent road could be put up there without without a lot of runoff into the stream. It was very challenging, to say the least.
Okay, so your problem with the easement isn't the easement itself,
Correct.
right? And I don't mean to put words into your mouth. but
You're
it's fair to
you're
say that
correct.
Your problem with the easement is how the easement has been used? Is that and I don't mean to put those words
No,
in your
you're
mouth.
not. That's, I bought the property, I was aware of the easement that was there, I accepted that. It was not a problem to me. The problem to me is the grading that has occurred above, not even so much on my property on the easement, but it's above that as it crosses over my property onto Mr. Stern's property, is what I would call a calamity.
Okay, in your opinion, and if I can't ask this, please someone, tell me, could something have been done other than what was done that would not have you upset about the use of the easement? Is there another way
Yes.
the easement could have been treated?
I do not believe, if using that easement, I do not believe that there is a reasonable path to a roadway that doesn't damage the environment.
So then what was the purpose of the easement in the first place, do you know?
Well, regulations change. I don't know when the steep slope ordinance occurred, but it was after that easement was granted. Regulations change and we have to deal with them. And I have done my best to help Mr. Stern find a way not to have to deal with laws that have changed since he bought the property.
Okay, thank you.
Craig, do you have anything?
Andy?
Yeah.
If I could make a note to the board very quickly, you did mention steep slope regulations. I did want to make a note that should a different route for a road be considered or done, we have not reviewed that for the steep slope regulations. So in steep slope, you can disturb up to, for a lot this size, 15% of the lot size or less, and 8% impervious. So who's to say, and this is again hypothetical, that if another road were to be put in, could that even meet steep slope regulations? So I did want to make that note as well, that one possible solution could cause another issue.
And that 50% is related to the disturbed area?
15%, yes.
15%, yeah.
And that includes all disturbance, excluding septic.
Okay.
So
Anything
did you
else?
hear that, Mr. Wilkie? That's
I'm
something,
not sure I understood, no.
go ahead, Savannah, explain again. Because it's going to be very important for you to consider with what you're going to propose to Mr. Wilkie.
Here we go. So when it comes to the steep slope in Buncombe County, each lot greater than 2 acres is subject to a disturbed and impervious surface limitation. What that means is that no more than 15% of the lot can be disturbed, and no more than 8% can be covered in impervious surface. Impervious is what water can't pass through, so that would be the structures themselves, gravel, driveways, pavement. So I just wanted to bring up before the board that should another avenue be considered for a road, we can't determine today whether it would meet even those regulations.
You cannot determine today, what was the last thing you said?
If the roadway, because I don't know what the roadway looks like, how long it is, how wide it is, if the roadway plus the home and all the other disturbance that may happen could meet zoning regulations. So there may, through that avenue, find a solution for the stormwater ordinance, but then you may not meet zoning regulations. Well, not you, but the property owner, excuse me.
Savannah, is it fair to assume that an engineer's report will take that into consideration?
So for the road, what we would determine, or what we would need is a surveyor or engineer to provide those numbers to us for total disturbance and impervious.
All right, thank you.
So it can't be calculated today, but we do see the plan to put the house on the lower left-hand side of the property. And if a driveway came up through the left-hand side of the property, the other driveway wouldn't be needed through the easement area. And so that's less driveway, right, overall. We just don't know the numbers. We can't certify it today, is what Savannah's saying.
I just think that what staff's trying to say is that there's no guarantee that option A or option B is going
Correct.
to work, and we want to make sure that's on the record.
Okay, thank you. Any further questions from the board for Mr. Wilkie?
Yeah, when the board's done, I just want to make sure that both I'm sorry,
Ms. Helly?
Ms. Selly
Ms. Selly, yeah.
and Mr. Golden also have a chance to ask
Thank
the
you.
witness questions.
Thank you, they will. Any more board questions?
I'm just recalling from our last meeting, and I thought I recalled there was some discussion about accessing Mr. Stern's property directly across the creek,
Through a bridge.
through like a bridge or a culvert. Am I vaguely correct on that or not? That would be further up the common driveway past.
Correct. There are two proposed, two options that I proposed that he consider. One was just off of my property, which the grading contractor disagreed with me, but I thought the easiest, and although it would be longer, would be to start about 100, I'm guessing 75 to 100 yards off of Old Fort Road and come up and gradually work. But there is another one where Mr. Stern's property further up, it was the second option that I had offered 3 years ago, that he could cut in there, and there would be some switchbacks in there. And that would not impact my property nearly as much. It would be better for me if he took that one, but I thought it would be better for him if he came down closer to Old Fort Road. I don't care which one he takes, if he takes one of them.
And In those conversations, was there any consideration of whether that would avoid the issue that we're here to discuss, and that's the variance for the 30-foot setback because of the water, the creek?
All of this would be occurring on the other side of the road from the creek. It's far removed from the creek. It's well outside. Either one of these options are well outside the required setback for the creek.
Victoria, do you have any input on this alternative that was way beyond, around the corner, up where Mr. Stern's property comes extremely close to the creek itself?
If I could suggest, can we finish with one witness before we?
Okay.
I-
I'm just trying to
I
get
would
to
like
the point.
Sure, we can.
If you could just hold on to that, and then we can recall.
Any further questions for Mr. Wilkie from the board? All right, any redirect from Mr. Maselli?
Yes, I'd like to ask you just a question or two, Mr. Wilkie.
Okay.
All right. Specifically, you did mention having a conversation with Mr. Stern, actually, I believe it was in this room directly after the last meeting?
Yes.
Okay. What was your intent with that conversation?
Well, my initial question to him, I was astounded that he did not recall any of the conversations that happened a couple of years ago, and I asked him about those. He assured me he had no recollection of any meetings with me or with contractors, the grading contractors.
Okay. And during that conversation, were you still attempting to show him alternate access?
Yes.
Okay. You mentioned you were approached by Mr. Goldman in that conversation.
Mr. who?
Oh, Mr. Stern's attorney.
Oh.
It's Mr. Goldman, correct?
Golden, yes, thank you.
Goldman, okay. Yeah, what did he say to you? Do you recall?
Hold on. By asking what Mr. Golden says, you were potentially making Mr. Golden now a witness.
Okay.
If you can ask him what his recollection is of the conversation or whatnot, but
Okay,
when
what
you
the
start
recollection,
asking him
not the
specifically.
specific statement, but the recollection, okay. Do you recall if Mr. Goldman made any stipulations on utilizing an alternate access in terms of cost incurred?
Well, again, I think that I'm just going to object to that. I guess I'm not a party opponent. Anything that he would say that I said is complete hearsay unless I do become a witness. I don't want to become a witness in this case.
Well, let me kind of preface this by saying I certainly do not pretend to be able to recall any exact wording of what anybody said. My recollection is that I was talking to Al Stern about a possible more advantageous route to his property. My recollection is that his attorney said, well, you need to pay, you need to pay for that. That may or may not be correct, and maybe I shouldn't even say that.
Hold on, there's an objection.
Yeah, I'm just going to object
Sustain
and
that.
move to
Sustain
strike.
it.
Okay, strike.
Strike, yeah.
No further questions then.
Okay. Mr. Golden, any cross?
Yeah, just a few to follow up on some of the board's questions. Mr. Wilkie, thank you for clarifying on this letter. So I'm going to ask that it be published again on the screen. So you see that letter there. You assured the board, you testified to the board that that fairly and accurately represents a copy of the original that was sent to Mr. Stern. Is that correct?
Yes.
And down here, I'm going to try to pull this out for you. Down here, it says, I am fully aware of the legal implications of this declaration and understand that any fraudulent statement can result in penalties under law. Do you recall saying that?
Yeah, I recall that being on there.
All right. And so if we go up to here, the paragraph that starts with during your testimony at the hearing, can you read that for the board? It might be on your screen.
I've got it here
Okay.
on paper copy.
Do you want me,
Uh,
can you read that?
Should I read it out loud?
Yeah, can you read it for the board? Can you just read it?
Sure. During your testimony at the hearing on June 11th, 2025, you stated your ultimate goal for your property is the construction of a home site to serve as your primary residence in retirement. As stated in the variance application, the current access to this property is limited to a deeded right-of-way that is less than 30 feet landward of surface water. Thus, the passing of this variance is a requirement to access your property.
And that was your statement that you made to Mr. Stern.
Objection.
That's what's in this letter.
Objection, in this,
Overruled.
well, may I
Yeah,
explain?
please explain, yeah.
Yeah, the way this is stated is that he's saying that Mr. Stern attests that the access to the property requires the passing of this variance.
He's
Mr.
reading.
Wilkie's
he's
not
read-
saying that
sorry,
he is.
He's reading the letter that has been submitted already.
Yeah, I was objecting to
allowed.
what
Well,
Mr.
I am reciting,
He's not recalling any conversation.
I am reciting there,
Yeah.
as stated in the variance application.
Is overruled.
Okay.
Thank you.
And you were asked about a alternate road that was proposed by Mr. Stern. You were asked that by Mr. Allen. You recall that? He was just asking you about an alternate access further up your road to get to Mr. Stern's property. Alternate accesses further up your road to access Mr. Stern's property.
Well, all the road is mine. Up the road from where? From where this,
All right,
from where the easements
So see on your
begins?
screen right there?
Yes.
Do you recall talking to Mr. Stern? Now, let me get this. Do you recognize this map and where it is and what it depicts?
Yes.
All right,
Yeah.
and so the white area that comes up is the roadway to your house, correct?
That's correct.
And the red area is, in essence, basically the deeded right-of-way that Mr. Stern has to access his house, correct?
That's correct.
And so there was discussion at the last meeting about you and Mr. Stern talking about this black area right in here. Do you see that? You see the black area right here? I mean, it's right there.
Yes, yes.
All right? Is that one of the alternate accesses that you offered Mr. Stern?
No.
Those would be my questions.
Thank you. Thank you, Mr. Wilkie. We're all set.
Mr. Wilkie, do you have any other witnesses that you wish to present regarding your case?
I do not.
Thank you.
Thank you. And Mr. Maselli.
First, Mr. Maselli, do you have any witnesses that you wish to present?
No, I do not have any witnesses. I do have some evidence I would like to admit.
Okay, if you could then go up to the lectern, so you will be basically making a statement and testifying as a witness.
Okay.
Thank you.
Okay, I'll start with the statement. So, yeah, at the close of last month's meeting, the board had encouraged all parties to have conversations about all other options. This included potential alternate access for a road that would eliminate the need for a variance. I believe one board member, Ms. Morisani, had stated, "I think people need to get out of their stances and start coming together because you guys all have to live together." I truly hope that this would be the case. Even in the aftermath of Helene, our community did pull together, and we showed how we cared about the well-being of our neighbors through action. Families and small businesses like mine donated our time, supplies, hosted fundraisers, and did what we could to assist our neighbors. I personally am not able to offer Mr. Stern access through my property, as it's not adjacent to his lot, it's downstream. I also don't really have the funds to pay for an engineer out of pocket to design a new roadway for Mr. Stern, as we face significant financial challenges since Helene. Maybe as a community, we can come together and do that, but it is another challenge. My business has been impacted by Helene, and our community on Echo Lake is facing huge